Good afternoon, everybody. Thank you for being here. I'm joined by Special Counsel for Reproductive Rights, Alma Nunley and Emily Gate with the Office of the Attorney General. We have a lot of folks here today, a lot of legislators. Thank you for coming from across the street. Thank you, Republicans and Democrats, for being here today in a show of bipartisan strength and force. I want to start by thanking the advocates. We're going to hear from our advocate partners here today, but I want to thank the advocates and the legislators and our United States Senator and the federal delegation and the governor and lieutenant governor. Because of them and their work and the work in our office, abortion is safe, legal, and accessible here in Connecticut right now, and it's going to stay that way. And so is access to a safe and vital medication known as mifepristone, which is why we're here today. So, it's been almost 2 years since the Supreme Court issued the Dobbs decision and blew a huge hole in fundamental rights for women, patients, doctors, nurses, healthcare in this country. And when the Supreme Court rolled back Roe versus Wade almost 2 years ago, I said that the fall of Roe was not the end of this fight, that it was just the beginning, and that after Roe fell, they would come for us, and they would try to pass a nationwide ban on abortion. And so they have. And so they're trying this morning in the U.S. Supreme Court. Here we are again, almost 2 years after the fall of Roe, on the brink, staring down another attack on women, patients, doctors, nurses, healthcare, abortion in this country. Just this morning, they just completed oral arguments in the United States Supreme Court in the case of FDA versus the Alliance for Hippocratic Medicine. I must tell you that the irony of the names in the hypocrisy are too much to bear sometime. But we are here because a district court, a district judge, a federal district judge in Amarillo, Texas, just the right judge who the plaintiffs looked for, issued an outrageous decision, right? A misogynistic political tone that purports to outlaw access to mifepristone. Mifepristone, by the way, is medication. It's one half of the medication that you take for a medication abortion, which is one half of all abortions in this country. It has been used more than 5.6 million times by 5.6 million American women safely, including hundreds of thousands of Connecticut women. There is nothing wrong with mifepristone. But this federal judge goes back to all these arcane laws like the Comstock Act. By the way, the Comstock Act was passed by Congress before there was an attorney general in this state, before 1897, before women could vote, before mifepristone was even a thought. And he purports to use this act, which was passed then in the 1800s to protect the virtue of women, right? That's when they passed laws like that. And he purports to use that and other technical arguments to say that a drug that's been reviewed by the FDA more than 4 times, approved more than 4 times, has been in use safely for more than 20 years. There's no evidence that it poses any unreasonable risk to any patient and any person he purports to outlaw. And then that case was appealed by the FDA to the Fifth Circuit, and the Fifth Circuit, in another decision that really has no basis, it doesn't make any sense, purports to roll back the use of mifepristone and standards around mifepristone to prior to 2016, when science since 2016 has told us that we should be prescribing and administering mifepristone in a different and safer way. And so actually the Fifth Circuit case puts people at risk, puts women at risk because it is against science and against medicine, and now we're before the Supreme Court. Let us be clear what this case is. It is not a technical case about about medicine, and it's not a technical case about administrative law and about the FDA. This is an attempt to effect a nationwide ban on abortion, period, full stop. That's what this is. You want to outlaw abortion, you take half of them out of the equation. You take medication out of the equation. This is an attack on women and patients and doctors and nurses, and it represents their full frontal assault on abortion. We're not going to let it happen. They just finished arguments in the U.S. Supreme Court, and we had a chance to take in some of that argument. And about 75% of the argument was about standing. Standing is the fundamental legal proposition that somebody has to have a reason, they have to have standing to be in court, right? You have to prove standing that you've suffered some injury, you've been aggrieved in some way, there's some reason for you to be there. And this Supreme Court actually spent 75% of the time on standing because many of the justices appeared to be skeptical about standing. That these doctors who have come to this federal court in Texas don't have standing. Because how have they been harmed? They're not patients. They've not been asked to do anything. They've not been asked to prescribe medication in a way that they don't want. As providers, they have not been harmed, injured, or implicated in any way. So what is their standing? And that is the point. What business is of yours? What business is it of the plaintiffs what a woman in Connecticut does with her own body? It is none of their damn business, which is why I hope and I'm encouraged by the argument today in front of the Supreme Court. But we're not going to wait for the Supreme Court, as you know. As I said, when this case first began, we're not going to sit back and let it happen to us again, right? We're not going to just take incoming. We're going to go on offense. And so we did. We went into federal court in Washington State. We filed our own action against the FDA to say the FDA has to do more to protect access to mifepristone. And because me and 17 other attorneys general went into court in that case, mifepristone is safe, legal, and accessible in Connecticut right now. So let me just close by saying, I've said it many times, it doesn't matter where this fight takes us, we are going to be there. We were in the Supreme Court today as amicus, and so were so many others. Actually, state attorneys general were in this case as amicus, as were the governors. Governor Lamont joined 22 governors in filing their own amicus brief. The congressional delegation joined an amicus brief signed by 263 members of Congress. More than 600 state legislators, many of whom are here, signed on to their own amicus brief. You guys are going to put me out of business. Senator Blumenthal has been there on the front lines all the way in this fight. And so we're going to be in every fight, any court, anytime, any place. District court, state court, federal court, district court, court of appeals, U.S. Supreme Court, and if necessary, in the streets, okay, to protect women, patients, doctors, nurses, healthcare. Take a good look here at all of us standing together, okay? This is what bipartisan work, bipartisan strength, bipartisan unity and cooperation looks like, okay? This is what it looks like when there's no daylight between advocates and the legislature and constitutional officers, U.S. senators, the federal delegation, and the governor and lieutenant governor. There is no daylight between us. We are 100% on the same page. This is what it looks like when the sovereign state of Connecticut stands together and says that we will use all of our strength, power, and authority to protect women, patients, doctors, nurses, healthcare. That's what this looks like.